Good morning. This is Pat O'Connell calling to order the New Mexico Public Regulation Commission regular open meeting of Thursday, August 24th, 2023. It's 10 a.m. Mr. Cameron, can you call the roll?
Commissioner Aguilera,
Present.
Commissioner O'Connell,
Here.
Commissioner Ellison.
Present.
Mr. Chair, all commissioners are present. You have a quorum.
Thank you. Okay, so next item is Pledge of Allegiance and State Pledge. Pledge allegiance to the flag of the United States of America and to the republic which it stands, one nation under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, the symbol of perfect friendship among united cultures. All right, so next item is consideration and approval of the agenda. I'm not aware of any changes to the agenda, although I think just trying to budget for time, I would recommend that in the discussion and potential action section, we go ahead and put the budget last. That's okay. Are there any other suggestions or changes you want to make to the agenda?
I don't have any. I suppose not. I do want to comment on one of the cases though in the consent action items. So I guess I can say that when we get to the consent action items.
Very
Mr. Chair, can I make one correction?
Yeah.
I think this is probably the right place to do it on under discussion of potential action on number 4. The case number in the caption should be 39440, not 3944. Under potential settlement agreement in number S1 SC 3944. Should be a 0 on the end of that.
Okay, thank you. I'm not sure if we need a motion to approve those changes because all we're doing is reordering and noting a typo, but so I guess just to be safe, I move to approve the agenda with potential discussion and potential action items to be taken in this order. First, start with a discussion item from Arthur O'Donnell, then MacLean Keyroll, and then the item that Mr. Cameron just described, and then the budget.
My second. Hold on, can we clarify which item you were discussing, Mr. Cameron?
It's item 4 under discussion and potential action items.
I don't have an item 4. I don't have an item 4 either.
Well, item 4 was amended onto the agenda Monday morning. And also when we get to item 4, I'm kind of not expecting it to be an actual item, but
Okay.
if that makes sense, but it's on the agenda, it got posted just as a foreshadowing the events that would have precipitated needing to talk about that have not happened. So,
Okay.
Right. And I think the confusion also, I suffered from the same confusion this morning, was that after it was amended and posted on the website, it wasn't emailed back out to us. So that's why the agendas look different from the one that's on the website.
Okay.
yeah, so we'll have a better discussion of that when we get there, but that's what that is. Okay, so we have a motion to proceed with agenda with a reordering. Don't remember if we had a second.
It was seconded, I think.
A second, okay. Could you take the roll then?
Sure. Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Ellison.
Aye.
you have unanimous approval of the agenda.
Great, thank you. Okay, next item on the agenda is public comment. Patrick, do we have anyone registered for public comment?
Mr. Chair, we do not have anyone signed up, and I'm not aware of anyone in the hearing room wishing to provide comment.
Yeah, I'm not seeing anyone in the hearing room here for public comment, so we will move on. So next announcements, first, Office of General Counsel. I've asked General Counsel to do recitation for a meeting I wasn't in attendance for, so if you could do that, Mr. Cameron.
Sure, Mr. Chair. So the recitation is as follows. On August 15th, the commission minus the chair who was recused met in executive session, which was closed pursuant to NMSA. That exception is meeting subject to the attorney-client privilege pertaining to threatened or pending litigation in which the public body is or may become a participant. And I affirm for the record that the matters discussed in the closed session were limited only to those specified in the notice and agenda for that meeting. Specifically, litigation discussions regarding Supreme Court appeal case number S1 SC 39152 relating to PRC case number 20-00222-UT. And I further affirm that no official or final actions were taken.
Thank you. Do you have any other announcements?
Yes, Mr. Chair, I just wanted to briefly let the commissioners and the public, I guess, know that OGC has recently hired 3 new attorneys. They are starting in the next 3 pay cycles. So between now and October 2nd, we'll have 3 people coming on board. And once they do, I'll be sure to have them here and introduce them and let them, get to see the commissioners and say a little bit about themselves. So good news on the OGC front.
Great, thank you. Yeah, it's my understanding there's other new people that are soon to start here too, so maybe we'll have more than just OGC introductions in the next month. Next, just the announcements that I know to make. September 1st, there's going to be a public hearing on P&M's renewable plan. That hearing will be available on YouTube at least. So if you're interested in that case or would like to make public comment, you can find the instructions of how to participate on our webpage. We're also having another public comment session in Public Service Company of New Mexico's rate case. So that's going to be on August 31st, starting at 4 p.m. to 5:30 p.m. and will go longer if there's people there waiting to give public comment. The comment session is going to be again at the New Mexico 811 Call Before You Dig building. The address is 1021 Eubank Boulevard Northeast. That's on Eubank, just north of Lomas. There is parking available at that building. You can also sign up and provide public comment virtually at that session. And then finally, that public comment session precedes P&M's rate case public hearing, which will begin September 5th. So Tuesday after Labor Day. I think that's a 9 a.m. start. That hearing is going to be available via YouTube. There's also opportunity to provide public comment via Zoom on that if you're interested, but so go ahead, go to our webpage and get the instructions on how to register to do that. Commissioners, do you have any other announcements?
I do not. Not for me.
Okay, great, thank you. All right, next item on the agenda is approval of prior meeting minutes. We have minutes for the August 10th regular meeting available. I had a couple typo revisions that I uploaded into Board Effect, but beyond that, do you have any suggested changes to the minutes or?
I have just a small one. I just wanted to ask staff to take another look at the staff present section, just to make sure that, because I think it's a little bit different than what is here. And so I would just ask them to, to correct that in case to reflect accurately who was here and who wasn't.
And I just have a couple of small corrections. They may be the same ones that you've already corrected for. But under the communication with commissioners, I think we should strike after Chair O'Connell said, we should strike the rest of that sentence and combine it with Chair O'Connell said, there are 2 cases in front of the commission on grid modernization.
That makes sense.
And just on the next page, Chair O'Connell says he's met individually with the chief of staff to address his concerns. I think is along the lines of what we were discussing.
Yeah, those are accurate. The changes I made was misspelling of MacLean's name, and then there was a strike through on one of the items. But so anyway, those I thought were typos. So anyway, I guess I would move that we approve the minutes with the 3 comments provided by commissioners adopted.
I second.
Roll call, please.
Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Ellison.
Aye.
Yeah, unanimous approval, Mr. Chair.
Okay, thank you. Okay, so next is the consent action items. We have several cases on the consent agenda. Commissioner Ellison, I believe you wanted to say something about one of those, so you have the floor.
Thank you, Mr. Chair. My comment really was around what's number 6 on the consent action item utility agenda here, the 22101 UT, the Corona Wind North project. I know this has been a long time coming, and I understand that the company has met with staff and even perhaps prior to filing that. I guess my comment would be that this is an important thing, and it would have been preferable in my view to schedule some sort of a meeting or a time for the company to come in to make the case to the commission and present before the commission with maps and discussion. I know that there's extensive information in the record, and everything seems reasonable, but for something big like this, we have folks that are looking to build transmission lines that come in well before they're ready to apply, and here we've got a company that we're looking to approve their project and a brand new commission, and it would be nice to have them make a presentation to us. That was really my only comment.
I believe we could ask the transmission developers to make a presentation in an open meeting. Just if you want an overview of the line and to highlight what's happening there, in addition to considering this item on the agenda.
Right. I understand. I think so. I guess it just depends. I understand, this has been a long effort, and the company is looking for approval so that they can go forward with their financing. So I'm unsure whether we should, delay another 2 weeks and ask them to come in, or just vote on it is the question.
Well, I guess my response to that is I'm going to move that we adopt the items on the consent agenda.
I second.
Commissioner Ellison,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Aguilera,
Aye.
The motion passes unanimously, Mr. Chair.
Thank you. Okay, so next on the agenda are two regular action items for utility matters. Both are presentations by Mr. Fisk.
Good morning, Mr. Chairman.
Morning,
Commissioners.
Mr. Fisk.
So first matter, docket number 20-00104 UT is the El Paso Electric Company general rate case on remand from the New Mexico Supreme Court. The commission has before it the proposed order that I provided on Friday, I believe, and the order proposed by Commissioner Ellison. And of course, I've spoken with all three of you since submitting to you the proposed order that I drafted that would allow a regulatory asset to be, I'm sorry, there's one of these things open up. Sorry, there's a board effect now. If you click on something, it doesn't just open up. You have to find where it's opened up. It goes somewhere. Here it is. Okay. So the order that I prepared on Friday would have authorized EPE to create a regulatory asset as they requested, except that the regulatory asset would only include prospective amounts. In other words, amounts from the date of, as I had first drafted it, the date of this order going forward for the adjustments that would need to be made to rates so that the rates would be in line with the court's order, the court's decision, finding that 3 of the overturned items in the commission's final order in the rate case from back in June or July 2021, it would restore those to the revenue requirement or include those in the revenue requirement because they weren't there in the first place. And there would be adjustment going forward until new rates are adopted in the next rate case. But under this proposed order, it would only, the regulatory asset would only include prospective amounts and not any amounts accrued during the period of the appeal itself. And that was due to my understanding of the case law, the Mountain States and US West case, and staff's understanding as well that we would not be able to do such an adjustment lawfully. But after speaking to all three of you, obviously you saw from my revised memo, there were, I think all three of you had some of the same concerns and some different concerns about how to proceed. And all those were valid concerns. I know that there was Commissioner Aguilera was interested possibly in not deciding this matter or issuing any order today. But Commissioner Ellison and when I spoke to Commissioner O'Connell, he had also talked about, well, why don't we at least get the calculations from EPE that it was supposed to provide in response to the commission's order upon issuance of mandate, because EPE simply did not comply with that part of the order. They provided a recommendation to just wait to do regulatory asset and wait until the next rate case to calculate any amounts. So moving to Commissioner Ellison's proposed order, which I provided yesterday evening, that order would do precisely that. It would require EPE to provide those calculations It would note that EP, as noted by the city and Doñana County in their response to EPE's response to the order upon issuance of mandate, that this was an inexcusable failure to provide those calculations. EPE said in its response, it actually needed more time. I would have needed 4 weeks. But as the city pointed out, it's odd that they wouldn't have that EPE wouldn't have calculated those items shortly after receiving a court decision saying they were entitled to recover them. So that seemed just a little surprising. And also, EPE's recommendation was to do a regulatory asset, but that doesn't mean that they couldn't have also filed the calculations. So we know about the regulatory asset, what the size of that would be. So it really was inexcusable that EP did not provide that information, and Commissioner Ellison's order would require EP to provide that information on or before September 12th, and require staff to respond, to review the calculations and make sure that staff, to analyze and assess whether those calculations were accurate, and that'd be by September 26th. And then any other party to the matter could also respond on the same date. There'd be the same deadline for any other party to respond to that. And because EPE did disobey that order the first time, the order upon issuance of mandate, the proposed order would put EP on notice that that they may be subject to monetary penalties under the Public Utility Act if they fail to comply with this order, because that would be a second failure to comply, because this order does ask for the same information as noted in the order. The language isn't exactly the same as it was in the order upon issuance of mandate, because it's clarified a bit. Because I think in the first order upon issuance of mandate, the distinction of the two different types of adjustments. One being, if the retrospective adjustment would be more like a lump sum, a lump amount for a period of time, and then the perspective would be going forward as it accrues going forward on a monthly basis. And of course, this order would say this: the commission is not deciding that question as to whether the retrospective amount is collectible, just asking for all the calculations essentially that the commission asked for the first time. So with that, I will take any questions.
Yeah, thank you, Mr. Fisk. Any questions or discussion?
I think you just said this, but I just want to clarify further that the proposed order that Commissioner Ellison put forward does not answer any questions with respect to a regulatory asset or an effective date for recovery of the cost. It is going back to the prior order to request the information that should have been provided initially.
Yes, that is 100% correct. It doesn't decide whether a regulatory asset is appropriate in this case. It doesn't decide whether an adjustment for the retrospective period is appropriate. It asks for calculation for both the prospective and retroactive, and so it's not deciding whether the one is recoverable or both. And again, like I said, yeah, this does not say a regulatory asset is appropriate or inappropriate. It just asks for the information.
Okay. I did have a chance to read the latest edits that you sent. I think the paragraph that describes what information El Paso needs to provide needs some clarifications, because as I read it, I could interpret the paragraph in various ways, so. I mean, I don't know if we want to do this, here, or maybe just ask. If we do issue this order, ask OGC to make some further clarifications, but it wasn't entirely clear what we're asking for as written.
I leave it up to the commission, but I could certainly edit right here and now just to make sure that when I'm clarifying what needs to be clarified. But I'll leave it up to the commission.
At least, my intention behind this is that clearly in its previous rate case, EPE calculated a revenue requirement. And so the idea here was to redo that same revenue requirement calculation with these additional items in it that were specified by the Supreme Court. So to my mind, you don't need to really specify a point in time. You just need to say the previous rate cases revenue requirement calculation, please update that to include these three items. At least that's how I was looking at it.
And if I could just add, Commissioner Aguilera, yes, I mean, this is why I had to clarify, because in the order upon issuance of mandate, I think EPE did understand what it needed to provide. But I hope I've clarified here that set aside the retrospective part of it completely, because I'm just going to talk about the other part of it, including the three items in the revenue requirement would be like that part of it. The prospective part goes on in like any part of a revenue requirement, a rate set in a particular case, go on indefinitely. It's not that there's a certain amount for that recovery, is that those amounts that should have been allowed would have been part of a revenue requirement that was an annual revenue requirement going forward indefinitely. So it didn't really need a particular period until there's a next rate case with new rates. Those three items are considered not only recoverable, but representative, that as part of the base year, representative of expenses and if there were capital investments, I don't remember, going forward. So that part is just indefinitely going forward until there are new rates from a new rate case. So, that's why I agree with what Commissioner Ellison said. Recalculation of the revenue requirement, including those items, recalculation of the schedule rates designed to recover that revenue requirement. And then because, rate design involves more than the consideration. I mean, first of all, rate design must recover the revenue requirement. But then there's a lot of policy decisions and other types of decisions that are made in the rate design. So that's why I dropped this parenthetical saying, well, preserving the overall rate design adopted by the commission. That might become an issue if it's not, if that it was not possible, but I think that won't be a problem. So basically we'll be saying, tell us what the rate case would have resulted in if the commission had not had allowed those three items in the revenue requirement. And that would be, the revenue requirements on an annual basis, and the rates are stated, and then the scheduled rates would state what's actually charged each month to recover that. And of course, staff would have a chance to respond. And so that gets everything perspective. And then the issue is, whether, we're not deciding here whether it's lawful to recover the period, recover what was not recovered in the revenue requirement from the date of the effective date of the rates from the rate case to date of the issuance of mandate coming back to the commission. We're not deciding whether it's recoverable, but we are asking for a calculation of that. And actually, that's probably a calculation we don't necessarily need them to do, because we could just take, the revenue requirement that they weren't getting during that period and, multiply it by the period, but it's always best to just ask for the utility to provide all calculations. Even if I think that calculation would be relatively easy given the, once we know the recalculated revenue requirement. So, I hope that clarifies things a little. I mean, because I needed to clarify that because I think the first order, like I said, EP could have understood it, but it didn't really lay it out, I think, as clearly as this does. I hope.
Okay. Yeah, thank you. I think that's what I was reacting to, was that I think the initial order just asked for the information, whereas this order is also clarifying further the periods in time that we want the information. I think it's not making any findings, right, with respect to retroactive treatment. So I think innocuous in that sense that it's not actually making a finding there, but is requesting information.
Yeah, I appreciate that distinction, Commissioner. I agree with it. And I just want to say I appreciate the order Commissioner Ellison brought forward here. Two things. I see this as a calculus problem. Going forward, two options that are out there is just regulatory asset to deal with in the next rate case or a rate adjustment. I don't know how to decide which of those is the right thing to do unless I know how much money we're talking about. And so the calculus angle of that is we also don't know when EP is going to file their next rate case. So how big are we willing to let that regulatory asset become? So again, that's how much money are we talking about? So that's why I want the information that we asked for in the first place. And then secondary to that is it baffles me that El Paso could decide, hey, you don't need that information, so I'm not going to give it to you. So that's why I'm happy with putting them on notice that if you don't answer the question this time, you might face some consequences. So anyway, that's where I'm at on this. And it has nothing to do with the amount between rate case decision and Supreme Court mandate. It has to do with what decision do we need to make going forward. We asked El Paso for the information we needed to be able to evaluate that. They didn't give it to us. So that's where I'm at with this item that's in front of us. But I agree, all the bigger questions aren't being decided today, and arguing half of them can't be decided today because they didn't do what we asked them to do.
I certainly agree with those statements. I think the sooner we can get these calculations from El Paso, the better off we'll be, and El Paso will be. I agree that we do have to make a determination between adjusting rates now or having a regulatory asset, and the regulatory asset has a weighted adjusted cost of capital that it's appreciating at that rate, and we may well decide that the ratepayer would be better off with just an immediate adjustment, and so we really, the sooner we can get that information, the sooner we can make a decision on this case.
Any further discussion? I'd entertain a motion.
I move to adopt the version of the order I submitted. I'm not quite sure how to phrase it otherwise.
That would be, we just say Commissioner Ellison's proposed order. That's the order that would require EP to provide calculations.
Yes. So I propose that we adopt the order that strictly requests and requires EPE to provide the rate calculations.
I'll second that.
Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Ellison.
Aye.
The motion passes unanimously, Mr. Chair.
Thank you. Mr. Fisk, you also have the next item.
Thank you, Mr. Chairman, Commissioners. So this matter is another EPE matter, of course. This concerns the EPE's motion for a variance from its fuel clause methodology with regard to the February 2021 winter storm Uri. This would be a variance to allow EPE to collect. Of course, this is a period when natural gas prices increased quite a bit due to the winter storm and possibly other reasons. The former commission in December of last year issued its order adopting the recommended decision with modifications. The recommended decision had been to simply decide that the use by EPE of the Palo Verde nuclear generating unit number 3 at the proxy price that was established previously by the commission in previous orders was fully justified. That EPE had been the commission had expressly say the EPE could use this resource really in an unlimited way, unlimited circumstances, and that the proxy price would be considered going forward the lowest cost available resource, so that the EP would not need to worry about determining in a particular moment whether that resource was, would not need to test it against other resources that are in the market, but could simply use it. But the commission, that was the recommended decision, but the commission in that order adopting with modifications added that even though there was that language in previous orders, that there should be further proceedings just on that question as to whether it was truly the lowest cost available resource at the time of the storm in February 2021. And so this commission wanted to revisit that. There was a motion for hearing that was filed by EPE. Unfortunately, due to bad weather, the day on which the motion was to be heard and considered, the commission then lost the ability, because there was only a 20-day deadline, et cetera, for the commission to decide such a motion, and otherwise it's deemed denied. So that was deemed denied. And the city before the commission actually acknowledged in a subsequent order in this docket that that motion, whether it would not be a ruling on that motion, it had been deemed denied, and that was the effect of it. The city had taken that up on a petition for writ of mandamus to prevent the commission from rehearing the matter, reconsidering the matter, given that the motion had expired. Recently, in July, it was the beginning of July, the court dismissed that matter or denied the petition. The court didn't give any reasoning, but I presume that the court was relying on the fact that the commission said in the commission's response to the petition that the commission had no intention, the commission had filed an order saying that the commission realized that that motion had expired, that the commission had no intention of reconsidering the order and the manner of a motion for rehearing. And I don't remember the third point, but all the points were essentially that this petition is moot. Commission has no intention of doing what the city is trying to have the court prevent it from doing. So that having been accepted by the court and the petition denied, it came back to the commission's bailiwick here, and upon that, a couple of weeks later, after that decision came down, EPE filed this motion for procedural order. In line with the fact that the order of the commission in December required further proceedings. The bone of contention between EPE and the city, which opposes the motion, I think the city and Marilee Souls or Doñana County, the joint parties, as I call them in my memo and order, is the scope of those proceedings. EPE wants to include in the scope of the proceeding that would be before a hearing examiner, particular questions that, in my opinion, are relevant to this decision. Looking at a number of previous orders, because there were a number of orders over time that were issued by the commission while the special arrangement for EPE's use of Palo Verde Unit 3 energy and capacity were in place, because it was in place for a long time. And so EPE wants to address those orders and those cases because they are relevant to the interpretation of what EPE was allowed to rely upon at the time. The history of when EPE was allowed to use this resource. Did the commission ever require what the former commission required in December order, the evidence of what the actual options were at any time that EPE used this option, the proxy price and Palo Verde Unit number 3. And my proposed order would grant the motion that was filed by EPE because, as EPE argues, and I see this as being accurate, the commission does have the ability, it has leeway, has discretion to expand the scope of a proceeding. So this would be consistent with the order in December. It wouldn't be overturning it or rewriting it. It would just simply be saying, in addition to that question that was required for further proceeding, in addition to it, not eliminating it, the commission thinks these are relevant questions too. And in fact, hearing examiners often will look into additional questions that are related to if there's something that defines their scope, they'll often ask if they can look at additional questions, because simply as things come up, as the evidence is developed, these questions, other relevant questions often need to be answered. So this may get challenged by the city if the commission adopts this order, because the city may say, no, the commission is effectively reconsidering or redoing the order from December of last year, because the proceeding was only to be limited to this question. But again, I would say as EPE says, the commission has greater discretion in this area to look into additional evidentiary questions when there's a hearing before it. So with that, I'll take any questions.
Any questions or discussion?
Mr. Fisk, just to clarify, this order would go with the list of questions on page 4A through G that the hearing examiner would be charged with getting responses for these questions.
Yes, Commissioner, that's correct. And they're actually listed in the order, copied directly from EP's motion.
Seeing no further questions or discussion, I'll move to adopt the order granting El Paso Electric Company's motion for procedural order.
Seconded.
Commissioner Ellison?
Aye.
Commissioner O'Connell?
Aye.
Commissioner Aguilera.
Aye.
The motion passes unanimously, Mr. Chair.
Thank you, Mr. Fisk.
Thank you, Mr. Chairman, Commissioners.
Okay, so with the reordering on the agenda, next item is discussion item, matter into inquiry and potential rulemaking pertaining to utility compliance with Energy Transition Act. So hopefully I have Mr. O'Donnell online to start us off with presentation on description of that item.
Thank you, Mr. Chair and Commissioners. Today, what is on your agenda is opening up an inquiry into the ability and status of PNM's compliance with Section 10D of the Energy Transition Act. The Energy Transition Act, as you know, establishes guidelines for reaching a clean energy transformation by 2045. Mostly that has to do with increasing renewable energy in the utilities portfolio. But there are two provisions of the act that specify what we call carbon intensity, which is a limitation on the amount of carbon released by generation per megawatt hour. This particular section affects a utility. PNM is the only utility that would qualify, that receives a financing order for the abandonment of a coal plant and issues bonds for the securitization of the stranded costs and other costs associated with making that transition for communities. The section had established a January 1, 2023 date for such a utility to have reduced its carbon intensity to 400 pounds per megawatt hour, with a subsequent requirement by the year 2032 to reduce that to 200 pounds per megawatt hour. What we're talking about now is the fact that PNM is not in compliance or meeting that 2023 date for a number of reasons that we can get into. And there are also several questions that the commission has to answer about establishing a rule for this, for the implementation of this section. I said PNM currently calculates that its carbon intensity for the first 6 months of 2023 is over 500 pounds, that it projects being able to reduce it to below 400 by 2025, and the hangups have been, as we know, the delays in replacement resources for the San Juan generating station and supply chain issues that also delayed or caused termination to contracts, either to fill the San Juan replacement or the Palo Verde replacement. And looming on the horizon would be the impact of abandonment of the Four Corners power plant. The questions that the commission needs to answer have to do with the actual applicability of that January 1st, 2023 date. As I mentioned, there are two conditions for that requirement to take effect. One is the issuance of a finance order. The commission has issued a finance order, PNM, and the issuance of the bonds, the securitization, which PNM has not yet done. So there's a legal question of, does that January 1st date still operative? It is built into the act. The commission can't just ignore it, so we have to deal with it. The second question has to do with the time frame for evaluating the compliance with this mandate. The way that the act is written, it says that there's a 3-year compliance window. So that would mean that by the end of 2025, the PNM interprets it as if they can reach the below 400 pounds per megawatt hour, by that time they would be in compliance, even if they're behind now. That all depends on whether Four Corners is still operating or not. Other questions that were raised in the analysis of this is an interaction with PNM's integrated resource plan. In the 2021 plan, PNM made several statements that it was intending to comply with this provision of the ETA and had built in action items in order to accommodate the replacement resources. As we know, that requirement has not been met, And so there is an issue, it's really a procedural issue of should PNM file a notice to the commission of a material event that changes what was in the 2021 IRP. The IRP was not adopted by the commission, but the commission does have an interest in making sure that the utilities follow what they said in their previous IRPs, and if something has changed, that they should notify. This is not an unusual situation. In its concerns about resource adequacy over the past 2 years, the commission did order PNM to make a filing that explained the conditions for the fear that there might not be sufficient summer resources. And PNM did that, right? It's the same set of circumstances and facts. So I don't think that it would be a big problem to have PNM make a filing with particular regard to this issue, so that it does amend its prior IRP, and then that becomes part of the base for the IRP that is currently in process through stakeholder engagement. A couple of the other issues that were raised is what is the proper period for monitoring compliance. PNM suggests a 3-year average, although it is possible that the commission might prefer every year. In that 3-year period, the utility needs to come and show that they're making compliance efforts and reaching that goal. We have reporting requirements that are undetermined in the act, and also the issue of what do we do if the utility cannot meet this standard going forward. And I'm less concerned about the initial period than about that more stringent 200 pounds per megawatt compliance by 2032. All of these are reduced into the order that you have before you, that would issue questions to parties and schedule a workshop in early October so that the commission can move towards a rulemaking. All I can say is that we're not looking to assess blame here. The commission probably should have taken this up under the last commission, but somehow it didn't get, even though it had been talked about at one time, I recall, it did not get directed to start a rulemaking about this issue. So there's no time like the right time, and the right time is now to do this. With that, I'm happy to answer any questions. I'll also just point out that we've been working cooperatively with PNM on this. A number of times that we've engaged with them saying, what's going on with this? Their response was, we're waiting for the commission to issue a rulemaking. PNM did meet with staff a couple of weeks ago to go over its preliminary assessments of where they are in this process and what their recommendations might be, which form the basis of my recommendation to you that we proceed with opening up an inquiry that will eventually lead to a rulemaking. So with that, I'm happy to answer any questions. I also have PNM's presentation. If you want to see numbers, I can put them up on the screen, but they were included in my memo.
Yeah, thank you for that, Mr. O'Donnell. Was your last sentence a quote from a song, or did you make that up?
It's a common phrase that I learned growing up.
Oh, thank you. It was poetic. So anyway, want to make sure we gave credit where credit was good. So one thing I appreciate you pointing out in the presentation is that no time like the present, the law does say the commission is supposed to set a rule. So that to me is the big motivator of what's in here in front of us now. Hopefully designed a process that can respect the fact that this started off as a conversation. Let's continue the conversation, but we know we got to get to that point where we have a rule. So that's just wanted to emphasize a couple of points that you did make in your presentation, Mr. O'Donnell. So thank you for that. Having made my mini speech, is there any questions or discussion from the other commissioners?
Yes, there's no question in my mind that that we do need to do a rulemaking on this area. However, I do want to point out that that particular clause has not yet been triggered because it does call for compliance by utility that has received a financing order and has issued energy transition bonds. We're in the situation where one of those two things has happened, and to my mind, the legislature could have said for utility that abandons a coal-fired plant, but they chose not to. And I think the clear intent here is if a company, in this case, it can only be PNM, avails itself of the ability to do the bond securitization, then it's got to comply with these things. And obviously the utility has not availed itself of the ETA securitization. We think that's going to happen early next year, but we're not entirely sure when that's going to happen. And it also is to be measured and verified every 3 years. I guess it feels to me sort of like this is a fire drill, and I don't think we necessarily need to treat it as such. In my view, we've got a rulemaking priority and a schedule that we voted on, and I think we need to, when we're proposing a new rulemaking, we should go back to that that list of priorities and that schedule, and look to see how that would change our other plans, our schedule for other rulemaking. So while I see this as important, and that we have to do it, I think we ought to go back and look at our rulemaking schedule before we launch into this. So I'm going to move that we table this item until the next meeting.
If I might ask you a question, Commissioner, is there anything else that you would need in terms of information aside from the prioritization of rulemakings for us to work on in the interim?
Well, I think we'd want to see how it impacts the scheduling of our other rulemakings, the existing schedule that we have in place.
So we have a motion on the table to table. Is there a second?
I will second that. I do appreciate this being brought forward. It certainly is important. I think we could hold off for 2 weeks if we can get a better product here, and maybe refine the questions a little bit, but
well, I'm going to vote against the motion. Looks like I'm going to lose, but and the reason why is our requirement to make a rule is independent of what PNM did. So and then we had a discussion at the meeting last week talking about grid modernization plans and how it'd be preferable to have a rule in place before compliance begins. So that didn't happen in grid mod. We have that opportunity to do it now. We're not in control of when the bonds get sold. So this is an opportunity to be, I think, proactive, even though the commitment began on January 1st, and it's now August. And then to the point of didn't have time to look at it, I tried to make sure people had a heads up by mentioning it in the comments to commissioners 2 weeks ago. So it shouldn't have been a surprise that this was on the agenda. And frankly, I don't think this is a very difficult thing. Deciding to ask people questions is what we've got here. So anyway, that I respect the idea of, I do agree with and empathize with the idea of it be good to look at this in the context of all the other rulemakings we have. So appreciate that comment, but just explaining why I'm going to vote against tabling.
So in terms of the dates for a rulemaking, there, I don't recall seeing any dates for rulemaking. There are dates for workshops and responses. Is that correct?
The act itself does not establish a date by which the commission needs to adopt a rule. It just says that it needs to adopt a rule to put the draft order that's before you only sets a workshop date and comments date so that we can answer the 7 questions that are listed in that order. And then the commission can either move towards a rulemaking or some other policy mechanism that establishes what the policy should be around this, given the fact that there is uncertainty about whether that January 1st date is legally enforceable because of the circumstances that the utility is in. I'm indifferent. I just feel that we should query the utility and the stakeholders on their positions on this and move forward.
Okay. So I mean, I guess I have to say I don't have additional questions to ask. I think you did mention this, and so it's not a surprise. I was more, if other people need more time, I don't think it needs to be issued today. However, I'm not opposed to that. And just thinking in terms of, priorities, I think that the stakeholder involvement and the utility might be a little bit different than for this case than for others. I mean, obviously this is going to affect PNM, but it's not necessarily going to affect everybody. And I mean, it will affect staff here. So I guess that's also another thing that I was trying to consider. But if we're going to issue this week or next week, I guess I don't have a huge preference. And I would be fine issuing it today.
Any more discussion or questions? And we've got a motion on the table. It's been seconded to table. So could you call the roll, Mr. Cameron?
Commissioner Ellison.
Aye.
Commissioner O'Connell.
No.
Commissioner Aguilera.
No.
Mr. Chair, there are 2 no's and 1 yes for the motion.
So motion to table has failed. I'll go ahead and make a motion to adopt this initial order, opening docket, scheduling workshop, and requiring filing of responses to inquiries.
I second.
Commissioner Ellison.
Abstain.
Commissioner O'Connell.
Yes.
Commissioner Aguilera.
Aye.
You have 2 yeses and 1 abstention for the motion, Mr. Chair.
Right, thank you. The next item is another discussion item that we'll have a presentation from Maclee Kiro about utility cybersecurity preparedness. So Maclee, if you could take the chair here. So just by way of introduction, this is a presentation that I previewed at the last open meeting. It's just continuation of a process that was begun by the previous commission, and so anyway, just take it away, Mackley.
Thank you. Commissioners, thank you for allowing me to present here today. This goes without saying, but for the benefit of the streaming public, I'll say it anyway. We live in a society where our public utilities, our lights, our water, our energy are deeply woven into our daily lives. These utilities, like many things today, are vulnerable to threats, not just physical, including environmental, but digital as well. Imagine waking up one day and finding your city in darkness due to a cyber attack. I know it sounds like a plot from a thriller movie, right? But this is the reality we're facing. So with that said, I present to you my presentation on the public utility cybersecurity preparedness. It starts by highlighting my personal opinion on the importance of looking into cybersecurity now, then moving into the background on what the commission has done in the past, which Chair O'Connell has alluded to, before going into the methodology I chose to continue their work. And then I rounded up with an overview of my findings and suggestions for utilities. Next slide, please. With everything that's happening in the world of utilities and the world in general, you might be asking yourself, why now? Out of all the times to focus on cybersecurity of utilities, really, why now? The real question is, why not? Besides the potential to collapse infrastructure, let me provide some examples of cybersecurity and cyber attacks affecting utilities. In 2015, we had the first big global cyber attack with Ukraine, when they experienced an attack that left hundreds of thousands of homes without powers for 6 hours. We had a workshop earlier this week on reliability, so it's arguable those 6 hours without power is a major event. Now coming a lot closer to home, in 2020, our own PRC was hacked, leaving e-dockets down for several hours. And just last year, there was a cybersecurity breach that resulted in hackers stealing data from hundreds of electric utilities after attacking a US government contractor. Also, for what it's worth, we shouldn't get stuck on the idea that security is intrinsically tied to attacks. Security is also tied to accidental damage. We talked about extreme weather events a lot this summer. And what's an extreme weather event if not a bringer of accidental damage? What I'm saying is that cybersecurity is less about the cause of the breach and more about the effect. And as you see from this image on my slide, in 2020, the World Economic Forum found that on a global scale, 42% of utilities rated their cybersecurity preparedness as high. That's no bueno, it's less than half. To make matters worse, 54% of them expected an OT attack within a year. OT, for those that don't know, stands for operational technology, which is the use of the hardware and the physical processes that control the industrial infrastructure. But back to my point, when cyber attacks happens to utilities, it might seem like an isolated event separated by time, geography, et cetera, but it's really not because of how interconnected everything is. In fact, I'll go a step further and say not only is it not an isolated incident, it's a call to action. Next slide, please. So if cybersecurity attacks are a call to action, now the next question should be, how did we respond? Well, in 2022, driven by President Biden's push for enhanced cybersecurity measures and led by former Vice Chair Commissioner Joseph Maestas, the commission launched an inquiry into cybersecurity preparedness of 26 public utilities in the state, including co-ops. These utilities were asked to respond to a set of 25 questions that would provide a lens into their cybersecurity policies and overall readiness. Next slide, please. To make sense of this data that I received from the 26 utilities, I use a cybersecurity preparedness evaluation tool, also known as CPET. This tool was developed by NARUC to provide a comprehensive framework on cybersecurity preparedness. It's not just about identifying threats, it covers the entire gamut, from detection to protection to response. The gamut of core cybersecurity functions is then broken down into 9 topic areas to evaluate responses, and that evaluation is weighted against 6 maturity rating levels. Next slide, please. As you see on the slide, the CPET topic areas include everything from governance, risk management, legal compliance, incident response, and incident recovery. Additionally, the maturity rating goes from no criteria to level 4, optimize. For what it's worth, you have to appreciate the nuance that went into the maturity ratings. Not only is there a no criteria rating, but there's a no information rating. The difference being that one means that they don't have any policies or plans for a certain topic area. The other being that they didn't provide enough information to assign a rating, which brings me to our findings. Next slide. Our findings were revealing. I won't name names, but while a few utilities have established some protocols, only a handful can be considered level 3, mature. Why this disparity? Perhaps because some utilities opted for confidentiality over detailed responses, or more worrisome, maybe some utilities don't have a clear cybersecurity policy in place. The silver lining, those that were on top of the game were sticking to national cybersecurity standards, specifically the standards known as the NERC-CIP. To be fair, being subject to the NERC-CIP is a major deterrent to noncompliance because it could lead to hefty fines. I'm talking about $1 million per day per violations. From the responses that we received, only 4 of the 26 utilities are subject to these standards. Interestingly, only 1 utility provided comprehensive details in their responses. Before I go into a deep dive of specifics, I just want to expand a little on what the preliminary findings showed. Out of the 26 utilities that responded, only 50%, that is 13 utilities, relied on basic yes and no answers. These responses, while they tick the box, lack the depth needed for holistic cybersecurity preparedness analysis. While some of this might be attributed to the order's instructions, which lean towards a general response, it's concerning to see that some utilities have no cybersecurity policies in place. Next slide, please. As I wrap this up, here's a quick snapshot of where our utility stands in terms of CPAT maturity levels. Level 1 for initial was dominated by 16 utilities. Level 2 for established was achieved by 6 utilities. And level 3 for mature was attained by 4 utilities. It's vital to understand the landscape of our utilities preparedness. For utilities standing tall at level 3, it sets a gold standard. Their risk management strategies, collaborations with federal agencies, and commitment to regular testing of their plans are commendable. On the other hand, while some utilities do show strong facets in their preparedness, they lack the extent needed for a more mature level. Some utilities operating on draft policies surprisingly had a well-rounded approach to cybersecurity without having anything official. On the other hand, utilities have significant gaps, exposing them to many vulnerabilities. I say all this to say that while my findings paint a diverse picture of readiness across the board, each utility has a strength and areas for improvement. Given this distribution, the call is clear. A substantial number of our utilities, especially those at level 1, need to strengthen their cybersecurity measures. Relying on established standards like NERC-CIP or ISO 27002 can be an amazing way to start. But let's remember, ticking the boxes isn't enough. Cybersecurity demands a proactive approach. One option to reduce this high number of level 1 rankings might stem from our order's general response instructions. Therefore, I think it's prudent for us to issue a second bench request order, this time seeking detailed responses and even offering the utilities a mechanism to claim confidential or privileged treatment for the information that they provide. This is what I'm calling for, and I've prepared for the commission today. Whether or not we opt for this, the onus is still on the 26 utilities to regularly refine their cybersecurity strategies and keeping pace with the threat landscape. Commissioners, as we look ahead, remember that cybersecurity is not a destination, but a journey. Let's ensure that we're not just on the right path, but we're also moving forward with a purpose and determination. Next slide, please. Thank you, commissioners. And while I said I won't name names, I do want to highlight on this last slide the 4 utilities with the highest maturity levels based on the responses. Again, thank you, and I'm open and ready for any questions you may have.
Yeah, thank you for that. And congratulations on your first presentation here at the commission. One question I had is, you just remind us when the responses came in for the initial inquiry?
November 2022.
Okay, so just a little less than a year ago. So is it possible that progress has been made on, would that be another reason to want to issue a new bench request?
Yes, Commissioner, it's definitely possible. And I actually included in the order that if they've answered the questions already, to provide an updated response.
Thank you for that. Commissioners, do you have any discussion or questions for MacLeod?
Thank you for distilling the information that was provided in response to the previous bench request. And I just want to clarify one thing that, with respect to the levels, that's something that you analyzed and that was your characterization of where the utilities fall. Thank you. I just wanted to clarify that. I guess I'm trying to balance a few things. So I thank you for the questions with respect to the second bench request. So can you maybe clarify how this, asking some of these questions again will help? Like, or, what is it that we can do to help, right? Because I guess the way I see it, maybe what we want to do is encourage and facilitate a plan for the utilities to improve.
Thank you, Commissioner. That's a great question. I actually included that question in the second order, asking the utilities what they think the commission can do to help and improve. Personally, I think we can, if we don't go to the NERC SIP level, we can establish some kind of standards and try to make it mandatory for the utilities to follow. So at least we all have them on a base level, on an even base level.
Okay. That's helpful. And, like some of those SIP standards are applicable to the transmission system. And so, I know there are those requirements, and here I think what we're asking about is not just the transmission system, but the distribution system, right? And so, like, how can some of those standards and lessons from the NERC SIP standards be applicable? And I think some of them are applicable to distribution, but not all of them. So thank you. The other thing, which I think there are hints of here, is with respect to physical security. Can you remind me, do we have any questions here with respect to physical security?
Yeah, there's one question that asks if they separate their IT from their OT. That's it, actually. So we'd have to, that was from the previous bench request. So we'd have to expand on that question if we want to get more in depth.
On your questions, Commissioner, you hit on something that I was struggling with also is, first of all, sense of urgency. This is an ongoing situation, and the fact that NERC SIP exists and it has existed for a long time shows that it's an important issue on a national level. Having said that, I looked through some of the responses to utilities, and this went out to everybody, including some very small co-ops. So made me question if they even had the capacity to answer the questions. So one of the things that showed up in a couple of the responses was a pooling of resources. So if that is happening, if it's improved in a year, those are the kind of things that I'm hoping to get from this. And I think that answers two questions: is if people are just struggling even to be able to answer the questionnaire, and there's others who found ways to work in a pool to help. Can we connect those two together? I was encouraging MacLeod to not name names because I didn't want to say where the threats might be, where the unlocked doors are. But so anyway, that's why we're kind of dancing around that topic. But you had the same question I did, and so anyway, kind of thing that would be love to get an update. And then just personally, I just want to also give a shout out to Commissioner Maestas for starting the ball rolling. I know the questions came in at the end of last year, so want to honor what he did by picking the ball up. And so that's one of the things that I was hoping to get from today. Do you have any comments?
Yes, I guess one thing that comes to mind is whether a rulemaking is being contemplated here, or, if not, what do we see the next step as being?
Yeah, initially I wasn't contemplating rulemaking, but if the commission feels that's appropriate, I'm happy to go with that recommendation. But what I was looking for was a second bench request order to have them update the questions, update the responses to the questions.
Okay. I guess I had a similar thought about the rural electric co-ops, and I was thinking that it may be productive, instead of, asking all of the rural co-ops again, it may make sense to consult with NMPRC, since, they do represent 15 of the 16 co-ops, and they would have the overview and I think the resources to help think about this and talk about the state of cybersecurity in general at rural electric co-ops. I guess my gut feeling is, if we just ask them the same questions again, I'm just not sure we're going to get a different answer. At least that's my concern. One idea could be, to focus on the investor-owned utilities and NMPRC sort of as a first pass, and then, expand it later, depending on how that conversation with NMPRC goes and that information. So, it may be more productive to focus it a little bit more. I would hope that we have someone here who's going to evaluate it, whether that be yourself or someone else on staff, because we would be getting a lot of responses that need to be sorted through and evaluated. I do think it's interesting, the issue of confidentiality. I mean, I'm not sure that utilities want to file sensitive information and then say, oh, could you please make sure this is confidential? Maybe they'd like some assurances from the start that, the filings are going to be confidential. And I guess some other things that struck me, I do think it's important to think about what's actually connected, what's actually automated or connected to the internet. So if you've got a rural electric co-op that does not have any automated switchgear, it's pretty hard to hack into that system and, cause an outage. Or, if they've got their billing system it's not attached to the internet in any way, it's pretty hard to hack into that and cause problems. So, we're focusing a lot on, their cybersecurity plan, but it doesn't feel like, we're focusing on, what's actually connected to the internet, what's vulnerable. And maybe, we don't want to ask the vulnerability questions if we're not sure it's going to be, confidential information. So, in general, I don't have a problem with issuing bench requests. I just want to, help make sure that, we're getting some good information out of it, and that it's a useful exercise.
Yeah, I was just gonna follow up on that because when I read these questions, I almost see like the beginnings of a plan, right? Because it's asking certain questions, and I think the responses are either yes or no, which isn't going to give us a whole lot of information, but I think the questions are leading to, like, do you do this? And I think really the answer is you should be doing this. And so I sort of see a plan here. So that's why I'm sort of wondering, like, what can we do? You know, maybe there's a guidance document as opposed to asking, you know, yes or no questions. Can we provide guidance on things that these utilities should be doing or taking into consideration? And the same thing, you know, I'm a bit concerned with, you know, asking these questions and then some utilities saying, oh, no, we don't do that, because then, you know, it sort of highlights. And then if they said no last time and they still say no this time, then it's like, oh, well, they're not doing anything about it. So I don't want to highlight vulnerabilities.
Yeah, I can respond to a bit of that. Just Genesis for me with this was a presentation on cybersecurity at a NARUC. In fact, it was the training we attended in Washington, D.C. And so there are guidance documents out there NARUC has put out. And then having attended that presentation, yes, the lady who runs that program from NARUC has very strong feelings about what utilities should be doing. So it's not surprising that when you see NARUC's questions, and these aren't the same questions that were asked before, by the way, they come from the NARUC guidance document, mostly with some edits. So anyway, yeah, they are leading questions because the person who wrote the questions has strong feelings about the plan ought to look like. So anyway, just some background on that. And then I don't know, commissioners, if you have a proposal for what to do, if you want to proceed with asking this set of questions, or if you want to take this and change it somehow. I mean, do you have a preference?
I guess where I'm at right now is I wouldn't necessarily want to ask these questions, but it might be helpful to have a presentation about what a proper plan should look like. At least as a first step. And then once we explain that, you know, borrowing from NARUC's experience, then maybe we can start asking questions or somehow facilitating an avenue for utilities to be able to meet that plan.
And I agree, these questions seem to be, you know, a lot of them seem to be yes or no questions. So, you know, we shouldn't be surprised if the utility responds yes or no to these questions. You know, if we want more detail, then, you know, we should ask them in a way that invites more, you know, more of a response.
I'm hearing a desire to reframe this or ask different questions. Do I have a volunteer to take the lead on doing that?
It's a different question.
Because I mean, I'm unwilling to give up on the idea that this isn't important. I agree it's not as urgent as the previous item, because good news, the commission already has taken a step in this direction. So we're not starting from ground zero, and we don't have a law telling us we have to do something. But having said that, this is an ongoing threat, and it relates to a lot of things that I'm hoping the commission gets better at over time. For example, when I think about the need for a better emergency communications plan, and I think about what could cause the whole grid to go out quickly, this is one of them. So anyways, that's why I'm saying it's important, maybe not as urgent because we've already taken a step on that. And whether one of the commissioners wants to take the lead on next version of this, or if you have technical advisor or some other resource you want to bring to helping Meckley take the next evolution on that, I think that'd be great. I also think it's okay to issue this set of questions. So.
And just to clarify, so if we ask these questions, so for example, number 11 says, do you have a cybersecurity vulnerability management plan? I think that's yes or no. What are we expecting to learn from that?
Thanks for that question, Commissioner. We're using that example. We're expecting to learn what level of CPATs, at least using that same tool, are they evaluated against? So do they have no criteria? Do they have some criteria? Is it mature or is it level 4 optimized?
Okay, and then would that type of response be privileged, or for any of these? Will that one specifically, would that be privileged, or is that, public?
I guess it depends on the actual utility. So in the order, I put in a provision so they could file a protective order, actually, so they could, for their confidential and privileged communication or information that they share.
Okay. Not entirely sure how to move forward.
As I said, I'm not opposed to a bench request. I mean, we're asking for information here. I do think NRECA should somehow be looped into the process, given their role with the rural electric co-ops. This is an important area, and it's if this bench request were issued, it certainly wouldn't be the end of it. So yeah, I guess I'm saying I'm not opposed to it. I'm just not sure we're going to get everything we really need from it.
Okay, so what I'm hearing is desire for more time to sit with this. So I guess what I'll ask Meckley, if you could just spend the next week working with commissioners and their technical assistants and seeing if this can get sharpened up or a different approach. And then if you feel like we're ready, week from tomorrow, we can put it on the agenda for 2 weeks from now. But so.
Thank you, Chair, and thank you, Commissioners, for your concerns and recommendations. I'd be happy to take this on.
All right. And again, thank you for stepping up to the mic.
Yeah, thank you.
We're at 11:30. Our next. Oh, there's one item that my reordering is discussion of potential settlement agreement in the Supreme Court case S1 SC 39440. I put this on the agenda Monday, so that was part of the confusion. In response to current events, I wanted the commission to have the opportunity to act expeditiously if we needed to. But next action, I think, requires remand of that case from the Supreme Court to the commission. So my first question is, Mr. Cameron, as of the moment has that happened?
As Mr. Chair, as of the moment, literally, I'm on, I mean, depending on how much lag time there is, I suppose, between things getting posted and things happening at the Supreme Court. We have not received a motion to remand, nor has one been entered in the case.
Okay, so I'm gonna propose that's the extent of the discussion on this item, and then offer that we will act expeditiously if situations change. But just wanted to use the fact that the three of us are together in a noticed open meeting, that if we did have an action to take, we could take it, but since we don't have the case, there aren't any actions to take. Is my assessment. So seeing agreement on that, I think we will move to the fourth item now, discussion and potential action, which is a budget discussion led by Chief of Staff Troy Corey and our CFO Miranda Mascarenas. Yeah, that's what I was gonna ask is we're getting, I don't know how long this discussion is going to take. I want to make sure it takes as long as it needs to. So commissioners, if you're expecting to have lots of questions and discussion on this, then I think we definitely should take a break. Maybe we should anyway, but so see an agreement on that idea. Is half hour too long?
Yes.
Maybe 10
Yeah, I was
minutes.
thinking like 5 or 10 minutes.
Okay, we will take a 10-minute recess. So that means be back here at 11:46. Thank you. And you have the floor at 11:46.
Great, thank you.
Okay, so we're back. Next item on the agenda for discussion and potential action, and actually I think there's a required action, is the budget discussion. So take it away, Choya.
Thank you, commissioners. We're here to present the operating budget for FY25 as well as the expansion request that we've prepared. I want to also recognize the hard work, like before we even start, Miranda Mascarenas, our ASD director and CFO, and Lori Narvaez have been working literally around the clock on putting this together and making adjustments and just helping us get to a place where we can present this to you this morning. This is officially due September 1st, but since we are going to bi-weekly meetings and the idea is to not have as many special meetings, we really pushed to get this to you today. So we're very excited to be able to present that to you. So I want to take us through what we were thinking as we were putting this budget together for your consideration. What we did was we looked at the FY23 actuals. So that's the fiscal year that ended June 30th. Then we looked at the FY24 expected, and we built from there. So what did we actually spend? What do we think we're going to spend this year? And what do we need then next year? We also wanted to build in room for the feedback that you've all given us independently, and also what we've been hearing from our division directors and from our staff surveys. It's beautiful that we're doing this at the same time as we're doing the strategic plan, because we've been able to implement some of the suggestions that staff has given us through those feedback surveys. One of the things that we heard loud and clear from everybody we talked to is we need more room for professional development. And so we've tried to build in room for that, not only in training for payment for actual trainings like registration fees, but also the associated travel that goes along with that, so that we can pay for more than just the registration fee. We can actually send people to those trainings. The other thing that we've tried to build in is budget to bring in training for agency-wide needs, as well as a budget to bring in specialized expertise in the form of contractors, whether that's attorney contractors or expert contractors for unique issues, discrete issues and cases. We also have built a significant expansion request. And the reason why that is listed separately throughout these documents is because they are submitted and considered separately by the legislature, DFA, LFC. We don't want to entwine the two requests, because if we don't get the full expansion requests, trying to unwind that from the general operating budget would have been is a bear. So they're two separate and distinct requests. So as we're going through this presentation, we'll be first talking about the operating budget and second talking about the expansion request. A couple of other things to note. This presentation does not include the entire package that we will be presenting to the legislature at the next 30-day session. The entire package will be the general operating budget that you're seeing here today. It'll be the expansion request that you're seeing here today. And then on October 1st, our special and non-recurring appropriation requests are due. So in the month of September, Miranda and I will be back in front of you talking about the supplemental appropriation that we will be asking for to get us through the end of FY24, and for the non-recurring or special appropriations for special projects that we will be seeking. So today we're just looking at the general operating budget with the room that we've built in for the areas of concern, and then secondly, the expansion. So just a note on the process, the legislature considers our budget request as a package. We will have a hearing this fall and then another one or at least one in the spring during the session. And at that point, we will talk about all the requests, our general, our expansion, our special appropriations, and our supplemental. We'll talk about them all at once. But the legislature itself will consider them separately, and we will hear kind of piecemeal as they consider each of those, whether they're voted up or down through committee. So with that, I think I'll turn it over to Miranda to talk about the numbers that we've built.
Good afternoon, commissioners. As Choya mentioned, we'll be going over our base budget request first, and then we'll go into our expansion. So in front of you, the handout that I'm just provided you all is what we will be submitting it to DFA and LFC. It's called the S8 and the S9. The S8 is a higher level roll up and the S9 has the detail. Today's presentation, I'll go over even a little bit higher detail. So if you have any specific questions, please feel free. Within the S8, I just want to point to, we want to focus on the base column. That's the column we're looking at on the spreadsheet. The other columns refer to the expansion and then previous fiscal years. So when looking at that spreadsheet, please refer to that base budget column. Overall, agency-wide, we are looking at a decrease of 2.9% in our general fund request. That is 100% due to the transportation division moving over to DOT. We are moving over 15 FTE. So when you look at the agency as a whole, that is a reduction in our general fund request. It does not align with the actual amount that's moving to DOT, and I'll go into that a little bit further as we go through each category. As you will also see, we are requesting an increase in federal revenue of 1.6% or $15,600. And then our other revenue, which is our pipeline safety fee money that comes from our pipeline safety fee fund, we are requesting a 2.2% increase or $30,600. Overall, you will see the decrease in expenditures in our 200 categories is 3.3%, which equates to approximately $427,000. And again, that is due to the transfer of the transportation division. We are seeking an overall increase of $32,200 in our contractual services. And in our other expenditures, we are seeking an increase of $75,400. So now I'll go into a little bit more detail of each of those categories to give you kind of some background information. So within our 200s category, I did exclude transportation division from our fiscal year 24 OPBUD request to give you guys a more apples to apples visual of what's going on here. So overall, you'll see that if we exclude transportation and what was budgeted in fiscal year 24 in the OPBUD, we are actually seeking a $583,000 increase to salaries and benefits in P611, which is 7%. And in P613, we're seeking $131,800, which is a 4% increase in our salaries and benefits. So this aligns with what Choya had previously mentioned in regard to trying to find more opportunities to hire personnel and to be able to compensate them accordingly. I also want to point out our historical vacancy rate. In fiscal year 2022, overall agency-wide, our vacancy rate was 19.83%. We were able to decrease that a little bit more in 2023 to overall a 15.52%. And as of right now, for fiscal year 24, by the end of September, with all of the offer letters we have received back in hand, we are projecting a 5.17% vacancy rate, which is amazing across all of state government. So we are diligently working to fill positions, which also is another point to why we need an increase in our 200s category. We're filling positions, we're bringing people in. In regards to our contractual services category, as Choya mentioned, we are trying to increase that as well. Again, I took out the transportation division to be able to provide that visual. We are seeking in P611 policy and regulation a $26,500 increase, which is a 5% increase. And overall in program support, we are requesting a $5,700 increase, which is a 6% increase. So overall, we are trying to increase our contractual services category to make sure we are able to support the agency. Lastly, I'm going to go over our 400s category, which is our other category. And here I broke it down a little bit more in depth for you all. So agency-wide, excluding transportation division, we are requesting a 15% increase in our 400s category. The items I do want to highlight are particularly the travel, the in-state, out-of-state, and employee training and education. I did also exclude our pipeline safety division in these comparisons. And the reason I did that is to give you all a better visual of the other divisions. We know pipeline safety travels, so their travel budget is huge. So that would sort of skew the numbers we're looking at. So I want to make sure we're looking at agency-wide. We did make sure we compensated pipeline safety accordingly, but just to give you an overall visual. In regards to in-state travel, we did request a 52% increase in P611 for in-state travel. And this is part of our plan to get out in the state more, to do meetings statewide outside of Santa Fe. In regards to our out-of-state travel, we did request a 27% increase in P611 to allow additional out-of-state travel for trainings or whatever is needed for the agency. Also, in regards to employee training and education, we are requesting 124% increase in that line item. Unfortunately, our line has been very, in regards to overall, it's been a small piece of our budget, and we want to see that increase. In regards to P613, overall, we're seeking a 7% increase to our 400s category. Within that, we are requesting a 55% increase for in-state travel, a 75% increase in our out-of-state travel requests, and a 31% increase in our employee training and education. And again, you'll see those numbers aren't huge. However, because the line items were previously so small, we are seeing a significant increase in that request.
Could you clarify what falls under the other expenses for the that policy and regulation excluding transportation?
Yes, Commissioner. The other expenditure category, the 400s category, is all expenses other than contractual services and salaries and benefits. So it's sort of the catch-all for everything else. It includes travel, training, leases, rent for items, advertising. Trying to think of some of the higher line items, but basically everything that's not a contractual service or that's not salaries and benefits falls under the 400s category.
So that 126,000, is that a roll up of the numbers below it essentially?
Correct. In regards to P611, that is correct. That is the total request comparison excluding transportation division. And with that, I will stand for any questions regarding our base budget request.
Yeah, thank you for that presentation. This is the third presentation of the base budget we've had, so I don't have any new questions or other questions, but I really appreciate you providing the info, so more than just the three of us have heard it. So thank you.
I just want to point out, as our chief of staff mentioned earlier, that, you know, in discussing with staff across the employee, there was a big desire for professional development. And I think that this base budget really shows, you know, that's what we're responding to. So thank you. Just wanted to note that.
Ready to move on to expansion?
Appreciate the effort. No further questions.
Mr. Chair, since we submit them separately, I would ask for a vote on these separately. So the operating budget and then separately the expansion, if that's the will of the commission.
Yeah, that's a good suggestion. And then I understand as chair, I get to sign these things. So I have to sign two things is what you're doing.
Mr. Chair, yes. So I signed them for, just like last year's budget, I signed them for accuracy as the cabinet level position, and you sign them to represent the vote of the commission.
Okay, thank you. So then I guess I'll make the motion that we approve the base budget for fiscal year 2025 as proposed.
Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Ellison.
Aye.
The motion passes unanimously, Mr. Chair.
All right, thank you, Mr. Chair, Commissioners. We'll move on to the FY 25 expansion request. I think I stated early on in this presentation that the expansion request includes other things than just the position. It's also any of the, subscription fees and dues, the travel, everything that's associated to a person. So if we want to send them to training, it's included in the expansion request. If we need extra office space, that's included in the expansion request rather than the thing you just voted on. So I want you to keep that in mind as we're looking at this. The way that we came up with this expansion request is we started by creating a wish list. We talked to you all individually. We talked to the division directors. We took a look at the needs as I saw them as chief of staff. And really tried to hone in on the positions that were essential to take the agency to the next level, to follow your vision for what this agency is and could be. So we started with a wish list of 34 positions, 10 in pipeline safety. As you know, those are related to the additional miles of gathering pipeline that we've inherited. So those 10 positions are based on PHMSA recommendations and best practices. They also don't come out of the general fund. And so the way that we've been thinking about this is 10 positions plus whatever else, because it's the general fund generally that where the rubber hits the road, so to speak. So the 10 positions in pipeline safety, the wish list included 15 positions in the advisory side of the agency. It included 6 positions in the advocacy side of the agency, which includes the legal division and the utility division. And it included 3 other staff. So that would be in ASD, that's in consumer relations division. What we decided on after consulting with you all and with DFA and others was that a phased approach to this request would be best received for many reasons, but to limit the shock value of what we went in for and kind of align with what we're used to seeing at the legislature. So the approach that we've taken here in this proposal is kind of what we need now, in that we're either not doing it or we don't have staff dedicated to doing it. And the example that I will use is following the CAISO market. So right now, Commissioner Aguilera is doing that. That's a position that staff in other utility commissions around the country is doing. So it's not based solely on the commissioner. So that's a position that we're not doing now, or that we don't have staff doing now that we need. As opposed to, are we holding down the fort, but we could use more positions to do a better job at it. That was kind of the distinction that we drew here. So what we decided on was 24 positions, 10 pipeline safety plus 14. And that breaks down into 10 pipeline safety, 8 advisory staff, 3 advocacy staff, and 3 other staff. But that's not the whole story, because as we discussed, this is a phased approach. So right now, the FY 26 planned approach is to also ask for those other 10 staff positions that we're not asking for this year. And obviously that will be adjusted should the legislature not grant us all 14 positions, general fund positions that we're asking for. So the way that this is broken down, and again, you have the details of it, but high level for everyone to understand and follow along, is we're asking for 3 analysts in the commissions division. And we use that as an organizational representation, the division over which the commissioners oversee directly. So your technical advisors and your research pool. These 3 analysts in the org charts we circulated earlier this week have they're denoted to do specific jobs, market analyst, for example. So that's the intention with those. The two positions in general counsel's office is based on my years of experience managing caseloads. And that is in order to manage the caseload that office sees, they need at least two more positions to produce more and better written work, to cover things that aren't being covered right now, and to generally ensure that our general counsel do not burn out. Frankly, that's a daily worry of mine, because the attorneys that we have there are great, but they have a caseload that's immense, and we want to make sure that they're covered. We have also asked for 3 positions in the hearing examiners division, 2 of them to act as additional hearing examiners, 1 to act as a law clerk. And I mean that not as a law clerk as is the position description for the state personnel office, but as an actual law clerk, as judges have. Judges in district court and above have law clerks to help them research and write. It will be an immense help for our hearing examiners to also have at least 1 law clerk, if not more in the future, but we can start with 1. Then I'm going to skip CRD real quick and move to the utility division. These 3 positions are the analysts, I think, are self-explanatory. Again, if the commission side needs market analysts, then we also need people on the staff side to do that, on the advocacy side to do that. Right now, we do have staff members doing it, but it's on top of their other job of analyzing rate cases, providing testimony, and doing all the other work that they are otherwise tasked with. So we see this as lending a hand to our utility division. And then the compliance manager is something that, frankly, has been keeping me up at night, that we don't have one. I've talked with our utility division director about this. This person would be charged with tracking all of the filings that utilities are supposed to make under statute, under prior commission orders, and under rules, to make sure that we're on track and the utilities are on track with the filings that we've requested. Because from experience on the advocacy side of this world, there's a lot of things that interveners and utilities are supposed to be doing under commission orders that extend into the future, but we need someone in-house to track those. And then moving to the category of other staff, in the consumer relations division, we are seeking a mediator, a trained mediator, to act in a complaint resolution process between consumers and utilities. And we're also seeking a consumer advocate / community outreach. The reason it's a slash is because the consumer advocacy part of that job would be literally sitting with the consumers and helping them fill out complicated complaint forms, or helping them be specific as to what that complaint is, helping them navigate, say, if they wanted to file a complaint at FERC, helping the consumers do that. But because I don't anticipate that is a full-time job, we also want to be able to get out into the public and get out into places where people can learn about us, learn about what the PRC does, learn about how to interact with their utilities, and just generally raise awareness of consumer rights and how our agency can be of assistance. So that position would be a combined position. And then last but not least, we have 1 position in ASD to act as a grant writer and a grant manager. Right now, we have some federal grants, and Jason Montoya, our Bureau Chief of Pipeline Safety, manages those grants because those grants are directly and specifically for pipeline safety. But as we've seen in the last couple of months, there are a lot of grants out there that we're simply not equipped to go seek. Mary Jane and Art have done a wonderful job pinch hitting for us. But it would benefit this agency and the state to have a grant writer whose job it is to specifically seek out those grants and apply for them, as well as manage them when we're so lucky enough to get them. And with that, we'll stand for questions.
Yeah, thank you for that presentation. I'll just open it up for discussion or questions from any commissioners. So you get live incoming from all 3 of us.
Well, I just want to say I appreciate the level of effort and thought that went into putting this budget together, and appreciate your discussing it with staff and getting their input. I guess one sort of thing that came to mind on the commissioner side with the request for the expansion request for 3 research analysts. An alternative certainly could be to have an increased budget for contract work, so that we could go out to people who have had lots of experience in a field and get them to work on specific questions. So we're not asking for that here. We're looking to expand in-house staff. I think that's fine, but I do want to point out that other state agencies, such as the Attorney General's office, do rely on contract work for some of these specialized questions, and it's something I think that we could keep in mind for the future.
Thank you. And to follow up on that, there is a budget for contracts. So I'm wondering, can we avail ourselves of that option in addition to increasing the staffing?
Commissioners, I think it's an and, not an or. So yes, this year we've increased the budget for 300, which is where contractors would come from. Well, we would pay them from, is a better way to put it. So we have some increase there, but I think, as you mentioned, Commissioner Ellison, that is a lofty goal to do both, have in-house and a substantial contractor budget.
Yeah. Yeah, and the other thing that I would add to that is, what we wouldn't get in that situation is the institutional knowledge, and the ability to train ourselves and keep that knowledge in-house as well. Certainly not opposed to it, and I could definitely see situations where that would, prop us up even further. But
I certainly agree with that idea, and I do think it's important to have our own in-house analyst for that reason, for that organizational continuity. Clearly there are going to be some areas where let's say we want to reach out to a firm that does natural gas modeling and has a natural gas model of the United States and can do some different scenarios. We'll probably, in-house, we're not going to have that, at least initially. So if, we could supplement our in-house research with, really going to some, some outside consultants that have, specialties like that, I think it would be a good approach.
And this conversation, first of all, I agree with both of you. When I think about the ongoing stuff that we need institutional knowledge and help with, SPP is not going away, Cal ISO is not going away, so we do need permanent staff. We also are going to have important big topics that need one-off type help, but then that led me to thinking this is absolutely why we need this grant administrator, because I think that's one way that we might be able to bridge that gap, because then that's a way to increase our budget beyond what we're asking for here, because we can find revenue hopefully to help pay for some of those items. But because my understanding of 8 months so far is we're, again, kudos to Mary J and Art. They've been amazing at finding money for us. Generally, that's come from DOE and NARUC, and those are organizations that respect the fact that commissions might not have staff to administer grants. So it kind of limits you to those grants we might be able to get find revenue from sources that have more bureaucracy of, for lack of a better word, attached to applying for and administering grants. So I'm hoping that we can get this expansion approved, can get this grant administrators up and running, and then get to the day where we have budgeted the ability to do both of the things that we clearly need to do. That's just my 2 cents on that one. And broadly, I appreciate the approach you took. It's easy for me to see what we need now. And so I think that's what we're asking for here. Everything that's on here, I'll have no problem talking to anybody in New Mexico saying this budget's legit. It's harder for me to imagine if we get beyond just what we need, what the state will benefit from. So it gives us an opportunity to fight for this budget and then grow into our understanding. So when we ask for the next round, we've got a more compelling, sharper story than I might be able to provide today. But I got no problem arguing for this expansion that we've got in front of us now, both from point of view of this is what the commission needs, and being a New Mexican who pays taxes. I can see it working from both of those directions. So anyway, also echo kudos to the amount of work you have done. One of the things I totally appreciated getting here, I'd say I thought this was true 8 months ago. By 6 months ago, I really respected the fact that I never worked in state government. So having that institutional knowledge represented by the team who put this together, I respected it. And this shows why it should be respected. This wasn't easy. So thank you.
Yeah, I also want to add my thanks for all the work that went into this. I mean, I had maybe like 4 meetings with you guys and then several other with Choi. And so I appreciate the effort that went into listening to me, but also listening to, other people in the agency to see what it is that we need. I think this is a good balanced approach. I will admit that I, for a while looked at the wish list and, wanted to go for that. But, that's why we have you guys who know a lot more about this than I do. And I think this is a good strategy and a sound approach. Thank you also for, at times holding my hands through these. This is definitely new to me. And so I appreciate your patience and the explanations that you provided.
And then while we're doing shout outs, I have to give Renata a shout out too, because I've been doing the corporate joke of just blame everything on her because she's gone, right? But that's not true. That you're building on a strong foundation. So I just want to acknowledge her efforts also. Okay, so do we have any more discussion, questions? I mean, I guess having gone through the process of what, the Goldilocks approach to this is too hot, that's too cold, this feels just right. That's kind of where I'm at now. Going forward process, we've got quite a few. Now we have to convince others that this is the right approach. So I guess that's where I'm at mentally. So before I jump there, maybe we should vote on whether to approve the proposed expansion or not. So I'll go ahead and move to approve the expansion as proposed today, and then just, is there a second?
Second.
Commissioner Aguilera,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Ellison.
Aye.
The motion passes unanimously, Mr. Chair.
Okay, so then before we let you go, could you just give us a preview of what happens next?
So Mr. Chair, immediately what happens next is Miranda and Lori start furiously punching buttons into the BFM program. And we finalize all the odds and ends that go with the submission, the narrative portion, et cetera. In not next meeting, so not the meeting on the 7th, but the meeting at the end of September, we will be back before you with a prepared special appropriation request and a supplemental request. And the supplemental request will be fine-tuned by these ladies' calculations based on what we need to get the 200 category through the end of fiscal year 24. And the special appropriation request, we are currently out for a request for information targeting 3 areas of IT growth, document management, case management, and e-filing and e-docket. Once we have the prices, or more like a range of prices that we hope to get from that request for information, we'll fine tune that special appropriation, non-recurrent appropriation request and be back in front of you presenting that. After that, assuming that gets approved by this commission, the entire package is presented to LFC. We'll have a hearing sometime probably in November, maybe early December on that. I'm sorry, I skipped a step. Before that, we will get the governor's recommended budget. So we will know whether or not she supports some or all of our budget request. That's likely to come at the end of October.
Commissioners, I might also add, we have been scheduled, I don't think we have a set date, but we have been scheduled to present at an interim committee hearing in October. And they have asked that we present the budget. So this will be our first presentation of the budget to the legislative body. And as Troya said, we will probably have additional interim committee hearings starting in November. And then multiple after that is starting in January.
No rest for the weary, huh? So anyway, thank you. Do you have any other questions or comments while we have Miranda? No questions. All right, thank you, Miranda.
Thank you all very much.
Looking at my agenda, and we left off Chief of Staff this week, maybe.
Oh, shoot.
We can't talk to you anymore. You're not on the agenda.
Right.
So anyway, I guess one of the things that came up in this meeting, just heads up for 2 weeks from now, it'd be great to have a sanity check update on where we're at on that raft of rulemakings.
It's funny that you should mention that, Mr. Chair. I actually had prepared to update you all today, but I see that I'm not on the agenda. So
Well,
it
can I
wait.
make that a communication with commissioners item then?
Sure.
Because we're allowed to ask anybody in this room questions.
I would imagine so long as no action is taken. I'm looking at our general counsel.
I think as long as you don't take any action on it, that's okay.
I'm good at not acting.
You listen.
All right, thank you very much. I am going to share my screen then. Or maybe I'm going to. All right, so just as a table setting matter, this document Excel spreadsheet began in, I want to say April-ish, looking ahead to the things that were on our radar at that point. The color coding has changed a little bit with this presentation because things have changed a little bit and time has passed and we have a sharper look at what is out there. The other thing to note is that this is not a vote. And this hasn't been voted on. This has been a reflection, my interpretation of what I've heard from you over the months. And so it's subject to change. There's nothing saying that we have to do it this way. I just want that to be clear that this is not locked in per vote. So I highlighted this column. This is where we're at. We're in the week of August 21st already. The colors are generally what we anticipated when I put this together in April. If it was there when I put this together in April, the non-colored but bolded, like say anticipated final order, is what it looks like either actually, if it's already happened, or what I anticipate now given the intervening months. So you'll see over on the left-hand side that there's a couple of topics that are highlighted in yellow. Those are ones that were identified as being high priority, but we have not started yet for various reasons. The ones that are highlighted in pink are the ones that are new since we started keeping track of this in April. Now, it also reflects that some of these, except the cybersecurity, which did not pass today or did not get voted on today, have been opened. And I've tried to reflect the coming workshops on those. The other ones, RPS cost writer, we haven't gotten to the anticipated opening yet, so I haven't adjusted those. So if I may, I would like to ask for a discussion on these highlighted in yellow, because that's the information that I am missing to update this with feedback. But obviously it's your conversation, so you can take it anywhere you want.
No, I can't read that.
Yeah, I was gonna ask if you could make that a little bigger.
Looks like ants.
It's a little better.
Yes, when I'm done here. Okay. Is that better?
Yeah, I can read that. Okay, so first one is integrated distribution planning. I think that's the one that we just had a workshop this week, right? So.
Mr. Chair, and before Commissioner Ellison takes that, when we had originally put this together, we had lumped reliability standards in, not lumped it in, let me put it a different way. We had thought we would start with the reliability standards workshops and that the integrated distribution planning would be an offshoot of that. That's as I understood it when we put this together. I see Commissioner Ellison shaking his head, so maybe we all around had a misunderstanding.
No, I think the intention, at least, my intention was for the integrated distribution planning and the grid modernization to be linked together. That the reliability standards would be a separate topic.
Yeah, and then I guess my expectation after the last meeting was that Commissioner Ellison was going to start mapping out rulemaking for grid mod. And then I guess that would include integrated distribution planning. And then we'll try to figure out how to navigate the cases we haven't decided yet with that rulemaking.
And yeah, I was intending to talk about that I'd like to bring an order to our next open meeting that would propose to begin that grid mod integrated distribution planning workshop series. So I'd like to bring that order before us next week. And I did think about a series of workshops and have outlined a few of those workshops, and I can briefly go over those if that makes sense. But I feel that we can and should navigate through this issue that I believe that we can have this series of workshops and then go on to the rulemaking, even though we've got a couple of cases pending. I think, we know we shouldn't talk about the pending cases in these workshops, and I think we can avoid making statements that could be interpreted that we're biased about our views on the current cases. And clearly, since the current cases began before we began discussions on the workshops and the rulemaking, we'll obviously have to just rely on statute for our judgments around the current cases that are pending. So I personally believe that we'll be fine with that. And I think the commission has done that before. That last year, I understand that there was the Renewable Energy Act rulemaking that the commission was undergoing, and at the same time there were Renewable Energy Act applications pending from the utilities. That happens on an annual basis. So I do think that we can navigate that issue.
You have any more discussion on that?
So I think, is what we have here only rulemakings, or do we have workshops as well? For example, the one on regional markets.
These are everything that has been opened as an inquiry. So I've listed workshops as well.
Okay.
Just in case they
Oh.
turn into rules.
Oh, I see in pink, the RTO participation.
I mean, the title of it is rulemaking, but some of these things we just don't know if they're going to turn into rulemakings or not.
I'll change the title.
Okay.
Well, then just as an aside, that ETA emission limit provision, we were trying to figure out how to not do a rulemaking on that, because it's only one utility, it's only one very specific thing. It doesn't apply, but the law says rules. So that's how we ended up where we were. So we were trying to create a process again to honor the fact that P&M brought the issue to us to how to structure something, but it ends up, even if it's not a rulemaking, it's definitely an inquiry. So it's on this list. But I mean, I guess one of the things I didn't share earlier in the meeting that is also true is the presentation that Art described showed me that at a minimum, guidance from the commission would be very valuable. So the fact that the law says we got to pass a rule is like, all right, well, whatever guidance, it'll be guidance, but it'll be called a rule. So anyway, that, we're just talking about broadening what you're talking about here by going beyond rulemaking. So we've got a few hybrids out there. All right. So, did you?
I'm sorry. I just want to address one comment you made about us not taking a vote on this. We may not have taken a vote on this scheduling document, but I think we did take a vote on priorities. So, we can look back at that, but, I'm somewhat uncomfortable with a document that can just be changed and it changes our priorities without us having discussed it.
We can certainly go back and look at the minutes and make sure that we're all on the same page with regards to votes and whatnot. This doesn't change unless it's been discussed at an open meeting. So it's not as free as you may think.
That's good. I just want to make sure that if we've got a document that's expressing commission priorities, that it's been discussed with the commission.
Mr. Chair, Commissioner Ellison, I view this document as more as aiding scheduling than expressing priorities. That's for you guys.
They're saying what we're doing here is just seeing, are we living up to the priorities we set? Because, I mean, we set priorities and then actions have happened. Are we living up to it or falling short on what that commitment was? If we want to change priorities, we can do that too, but not here because it ain't on the agenda. So. Next item on yellow. Or did we cover all of them?
I guess I would ask whether you have any questions for us or clarifications, like specific clarifications on.
Mr. Chair, Commissioner, I don't think I have any specific clarifications because this is just my interpretation of what I hear happen at open meetings. It's, you know, not a firm representation of any specific thing. And this is a schedule of what might happen. It includes dates and other things that are happening at the agency. So for my purposes and the way that I've been using this is just following up with our staff as things get kicked off or we're approaching time to kick something off. Unless I've heard differently, then I follow up with, recently it's been Mr. Lundin, but just whoever would be the point person for that next thing.
Yeah, I mean, that same question Commissioner Aguilera had, are you getting the questions you came here with answered?
Mr. Chair, I didn't have any questions. I anticipated you all would, so
Okay.
that's why I was presenting.
All right, so I guess this has been helpful. Can you email that to us so I can read it, but maybe talk about it some more in 2 weeks.
I do have one question not related to the subject of this, but more as to the form. I've been keeping it true to what we looked at in April. It seems to me that it's getting a little unwieldy and hard to follow. So unless there's objection, I'm going to reformat it a little bit to make it easier to follow before I email it to anyone.
I'm opposed to improvement. Please do whatever you can do. All right, thank you.
Thank you.
Thank you.
Okay, so we were technically in communications with commissioners section of the agenda. I've got one item that National Digital Connectivity and Lifeline Awareness Week is September 11th through 15th. So that's new to me, but apparently it's something that happens every year. Got a communication from NARUC highlighting that, and it had a package of things different utility commissions do. It's worth highlighting because what they're doing is showing that there is lifeline programs that can provide eligible customers up to $9.25 off cost of phone, internet, or bundled services. It also provides eligible low-income households a discount of up to $30 a month for internet, $75 per month for qualifying tribal lands. Households can receive a one-time discount of up to $100 to purchase a laptop, desktop computer, tablet, and get contributions towards purchase price. So anyway, it's very worth highlighting nationally. When you think about New Mexico, I think it's critical to highlight it. So that came across my desk this week. I engaged Patrick Rodriguez and Mike Ripperger. Mike was like, hey, yeah, we do this every year. So that's good news. So he and Patrick are working together to create something from the New Mexico Public Regulation Commission that helps highlight the assistance that's available to New Mexicans. So just wanted to make sure both of you are aware of that, and I'll share with you this letter from NARUC that summarizes what that is. And And if you want more information about what we're doing, or you got some ideas, want to check in, Mike or Patrick are on it. So that's my list of communications. Commissioner Ellison, do you have anything?
I think the main thing I wanted to mention was about my intention to bring that order before the commission next open meeting on the grid mod and integrated distribution planning workshops. I can talk a little bit about some of those that I would foresee. I might mention just the first couple where, the first one, we may have someone come in to talk about the national perspective for grid modernization and why it makes sense to look at grid modernization and integrated distribution planning together. And we might even have a couple of speakers from other states to do lessons learned for states where they've already been through this, that they've had a statute put in place on grid mod, and they've adopted some rulemaking around it. Ideas for a second workshop could be to have the utilities come in and do presentations around how are they doing distribution planning today, and allowing for questions. So, I don't want to bore you with other workshop ideas here, but I think we've got some structure that we can put in place around some workshops in this area. I did want to mention that I issued a couple of bench requests since our last meeting. One was to El Paso Electric to follow up on some questions regarding their 2024 renewable energy plan. And then just yesterday, one to New Mexico Gas Company. And, the focus of that was really twofold. One was some further questions around what happened during Winter Storm Uri, and whether they would, first to get more information about what happened at that storage facility that New Mexico Gas was relying on in West Texas, and second to delve into this force majeure question, because at first glance there seems to me to be a discrepancy between how FERC views force majeure and how the Keystone gas storage facility views force majeure as in their contract, and to inquire about whether New Mexico Gas would consider filing a formal complaint at FERC. And then the second set of questioning really around their preparations for this coming winter, to understand better what their plans are, and whether they're again completely relying on this storage facility in Texas for their winter supplies. So I just want to let you know that those have gone out.
Yeah, thanks. And then that was frankly something I was on my list to bring up is, New Mexico Gas Company produces an annual gas supply plan that goes to staff. So, we had that workshop talking about gas prices in, I guess it was February, maybe. Maybe this fall, October or so is a great time, after they've got that annual gas supply plan and staff has seen it, for them to come in and present it to commission, because I think that would include the answers to the questions you have here, plus give us what their price outlook and how have they hedged and those type of things. So anyway, I think that would, sounds like you were on a similar track to me, but so that when you think that's a good propose a date for which open meeting you'd like that to happen, and we can get it on the agenda and get it scheduled. Commissioner Aguilera, do you have any?
Just wanted to update you on a training I had last week with Cynthia, and Ed Rilkoff went as well. That was put on by the Body of State Regulators Committee. And so it was about designing regional markets. It was, and then it was also a simulation about, like our generator and you're submitting bids, which is kind of like a game. And we were very competitive. I think we did well compared to the other commission. So definitely a different mentality to, try to make as most money from ratepayers as you can. That being said, I think one of the things that really stuck with me is about how you can design markets and what you can insert into a market to change the incentives or eliminate incentives that generators have. And you can design a market that is generator friendly, but that doesn't always mean you're designing a market that is that works for ratepayers. And so that's been on my mind a lot lately, following EDAM and Markets Plus. And so it was just really good timing for that training. Potentially one that I think we can have, bring the trainers, have them here in person. That's one thing that I was talking to Troy and Miranda about when we were designing the budget, making sure we had that flexibility. And of course, they had already thought about that. And so, yeah, I just wanted to update you on that. And that's all I have.
Yeah, thanks for that update. It sounded like a great training. I'd also heard a rumor that you're sponsoring and outfitting the PRC's pickleball team.
This is the first I've heard about that, since I never played pickleball, but I'm sure I could get up to speed quickly.
Yeah, Ed had told me that there was a plan afoot for a pickleball team, which I thought was a great idea, because we've got so many new faces and people who might not get injured by playing pickleball like I would. So anyway, Mr. Ellison, do you have anything else?
I don't think so. Thank you.
All right. Any opposition to adjournment? And we are adjourned.
Great.